What is the relationship between power of appointment and wills? Have you ever wondered how certain decisions about your assets can be made even after you are gone? The power of appointment is a key concept in estate planning that plays a significant role in wills. So, what exactly is the relationship between power of appointment and wills? Let's break it down. A power of appointment is a legal authority granted by a will or trust. This authority allows a designated person, known as the powerholder, to decide how specific property will be distributed after the original owner passes away. This flexibility is often included in wills to adapt to future changes that may arise, such as shifts in family dynamics or tax laws. In the context of wills, the power of appointment allows the testator, the person making the will, to delegate the decision of who receives certain assets. This means that the powerholder can choose beneficiaries or modify distributions among a specified group of people or organizations. There are two main types of powers of appointment relevant to wills. The first is the general power of appointment. This grants the powerholder broad authority to appoint property to themselves, their estate, their creditors, or the creditors of their estate. Because of this wide-ranging authority, property subject to a general power of appointment is often included in the powerholder's estate for tax purposes. The second type is the limited or special power of appointment. This restricts the powerholder's ability to appoint property only to a defined class of beneficiaries. For example, the powerholder might only be able to appoint property among descendants or for specific purposes like health, education, maintenance, or support. These restrictions can influence tax treatment and control over the property. In elder law and estate law, powers of appointment within wills are important for several reasons. They allow flexibility in estate distribution, which can be critical when planning for long-term care needs or changing family circumstances. They can also direct assets into charitable lead trusts or other charitable giving arrangements. This means the powerholder can appoint assets to charities under specific conditions. Additionally, powers of appointment help manage tax consequences by controlling who is considered the owner of the property for estate tax purposes. They also provide a mechanism to protect beneficiaries by limiting how and when assets are distributed. In practice, a will may include a power of appointment provision that gives a surviving spouse or another trusted individual the authority to decide how certain assets are divided after the testator's death. If the power is not exercised, the assets typically pass according to the default terms of the will or trust. Overall, the relationship between power of appointment and wills lies in the power's role as a flexible, legally recognized mechanism embedded in wills. It helps control the ultimate distribution of estate assets while balancing the testator's intent with future uncertainties and planning needs. This relationship is particularly relevant in elder law and estate planning, where managing asset distribution, tax implications, and beneficiary protections are key concerns.